Jefferson County Court at Law number 2 is back in session with our arraignment docket. First case we're calling is cause number 332-870. Case is styled the state of Texas versus Joseph Guidry. Joseph Guidry, please come forward. Mr. Guidry, is your full name Joseph Dennis Guidry?
Yes, sir.
Mr. Guidry, would you please raise your right hand? Mr. Guidry, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Guidry, you may put your hand down. How are you doing, Mr. Guidry?
A little exhausted. My mom, she broke her arm, so I've been taking care of her at night and everything. So,
Oh, okay.
yeah. And we're going to work, so it's a lot.
Yeah, I understand.
Yes, sir.
Well, good thing she has a son like you to take care of.
Yeah, because everybody else is not around right now, so trying to do my best.
Okay, well, keep up the good work. Now, Mr. Guidry, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendants?
Yes, sir.
And is that your, are these your initials on the line
Yes, sir.
stated that you have hired Wright Kimball as your attorney?
Yes, sir.
Mr. Guidry, your case is going to be, now, first of all, Mr. Guidry, prior to signing this document, did you read the document?
I was listening to you. I was trying to listen to you, but like I was trying to.
Okay, let me do this here. I'm gonna give you a, Mr. Porter. Could you hand this to him? You can just have a seat over there and just take a few minutes to read it. And then once you finish, we'll call you back up.
Yes, sir.
Okay,
Right here.
yeah, that's fine.
Okay.
Next case is cause number 332-158. Case is styled the state of Texas versus James Anthony Lindsay or James Lindsay Jr. Your full name is James Anthony Lindsay Jr.?
Yes, sir.
Mr. Lindsay, would you please raise your right hand? Mr. Lindsay, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You may put your hand down. How you doing, Mr. Lindsay?
Oh.
Doing great, that's good. Mr. Lindsay, I have before me a couple of documents. First document that I have is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
One thing without it.
Yeah, do you recognize the document?
Yes,
Okay, and is this your signature on the line that's titled Defendant?
yes, I wanted to get a court appointment.
Right, and these are your initials on the line that's titled, that states you want to apply for court-appointed attorney, is that correct?
Yes, sir.
I also have a document before me that is titled Affidavit of Injuries. Do you recognize this document?
Correct.
And on page 2 of this document, there's a signature above the line that is titled Defendant's Signature. That's your signature?
That's my signature.
Now, Mr. Lindsay, before you sign and initial all of these documents that I've just mentioned to you, did you read the documents?
Correct.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Lindsay, I've read your answers in these documents, and based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that has been appointed to represent you is Attorney Jack Lawrence. Mr. Lindsay, Mr. Lawrence is going to be given information on how to contact you, and you will be given information on how to contact him. Mr. Porter, could you get a hand, Mr. Lindsay? Now, Mr. Lindsay, our bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law number 2. Do you see that document, that title? I will go over this document with you, and it reads, following the arrest and or accusation in County Court at Law number 2 of Jefferson County, Texas, all bail bonds executed for release of any defendant named herein or ordered subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or the United States. Do you understand that condition?
Yes, sir.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court the court may revoke the bond and order arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submit to a test for drugs and alcohol, and the test indicates the presence of drugs or alcohol in the defendant's body. And do you understand that condition? And condition number 3, the defendant shall not communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition?
Yes.
And condition number 4 does not apply because it only applies in a DWI case. Your case is not a DWI case. If you violate any one of these conditions, your bond can be revoked. And if your bond is revoked, the warrant could be issued for your arrest, and you can be arrested and placed in the Jefferson County Jail. Do you understand? Okay. So at this time, Mr. Lindsay, you're gonna stand, that's your copy, but you're gonna stand on the 4X in front of our court coordinator. Once she gives you the information about how to contact your attorney, you'll be free to go, and you have a blessed day.
You too.
There you go. Joseph Gidry. Mr. Ford, good to get that paperwork from you. Okay, now, Mr. Gidry, earlier, you were sworn in, is that correct?
Yes, sir.
Now, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled
Yes, sir.
Defendant? Are these your initials on the line stating that you have hired Wright Kimler as your attorney?
Yes, sir.
Now, Mr. Gidry, before you signed and initialed this document, did you read the document?
Yes, sir.
Do you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Now, Mr. Gidry,
Yes, sir.
you're gonna stand on, first of all, you're gonna have a seat in the chair that you were sitting in.
Yes, sir.
And once our coordinator is ready for you at the window, you're gonna go to her window. Your case is gonna be reset.
Yes, sir.
Once your case is reset, you'll be free to go, and you have a blessed day, and continue to take care of your mom.
Yes, sir. Thank you.
Yeah, he's like said, he's already hired like that.
Excuse me, sir.
Warren Leday, court is in session and calls numbers 330-996, calls number 330-998, and calls number 333-110. All three cases are styled of State of Texas versus Warren Leday Jr. Mr. Leday, is that your full name?
Yes, sir.
Mr. Leday, would you please raise your right hand? Mr. Leday, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes, sir.
Mr. Leday, you may put your hand down. How you doing, Mr. Leday? That's good. Now, Mr. Leday, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Leday, do you recognize this document?
Yes, sir.
And he didn't even sign it. Yeah, he initials on one. Mr. Leday, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant? And are these your initials on the line stating you want to apply for a court-appointed attorney?
Yes, sir.
I also have before me a document that is titled Affidavit of Indigence. Do you recognize this document?
Yes, sir.
And at the top of this document, well, on the second page of this document, there is a signature above the line that is titled Defender Signature. Is that your signature? Now, Mr. Leday, before you sign and initial these documents, did you read the documents? Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge? Okay, now, Mr. Leday, I've read your answers in these documents. And based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is attorney Todd LeBlanc. Okay? You're gonna be given information on how to contact Mr. LeBlanc. Mr. LeBlanc will be given information on how to contact you. Now, our court coordinator is gonna reset your case. You're gonna get that information, and once you get that information, once you reset your case, you need to go with the bailiff. Okay? Todd LeBlanc. Stand on the X.
Okay.
Amber Johnson.
I think you have to put it in one time.
Okay, number one.
What are you trying to do? I'm just giving you all the information.
Hold on a minute. Okay, this is call number 326-824. Case is filed the state of Texas versus Amber Rejoice Johnson. Ms. Johnson, is that your full name? Ms. Johnson, would you please raise your right hand? Ms. Johnson, do you swear or affirm, tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ms. Johnson, you may put your hand down. How are you doing, Ms. Johnson?
Good.
Doing good? That's good. Now, Ms. Johnson, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. Do you recognize this document? Is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line that's titled, it states you want to apply for court-appointed attorney?
Yes, sir.
All right. And I have before me another document titled Affidavit of Indigence. And do you recognize this document? On page 2 of this same document, there's a set of initials that's titled Defendant Signature. Is that your signature?
Yes.
Talking, okay. Now, before you sign and initial these documents, did you recognize these documents?
Yes.
And did you read the documents? And is everything in these documents true and correct to the best of your knowledge? Okay. Ms. Johnson, I've read your answers in the documents. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. The attorney that's appointed to represent you in this case is Attorney John Macy. Attorney Macy will be given information on how to contact you, and you'll be given information on how to contact them. Mr. Porter, could you hand this to Ms. Johnson? Ms. Johnson, bailiff is handing you a document that is titled Standard Bond Conditions in County Court at Law Number 2. Do you see that, title? I will go over this, document, which it reads, following arrest and or accusation in County Court at Law Number 2 of Jefferson County, Texas. All bail bonds executed for release of any defendant named here in the order, subject to the following additional conditions. Number 1, the defendant shall commit no offense against the laws of this state, any other state, or of the United States. Do you understand that condition?
Yes.
Condition number 2, the defendant shall submit to testing for drugs and alcohol at any time as directed by the court. Court may revoke the bond and order the arrest of any defendant who A, refuses to submit to a test for drugs and alcohol when directed to do so by the court, or B, submits to a test for drugs and alcohol, and the test indicates the presence of drugs and alcohol in the defendant's body. Do you understand that condition? And condition number 3, the defendant shall now communicate either directly or indirectly with the alleged victim of the pending offense, and the defendant shall not go near any residence, school, or other location frequented by the alleged victim. Do you understand that condition? Okay, now, Ms. Johnson, if you violate any one of these conditions, your bond can be revoked, and if your bond is revoked, warrant could be issued for your arrest, and you can be arrested and placed in the Jefferson County Jail. Do you understand that? Now, our court coordinator is going to give you information on how to contact your attorney. You'll also be given information. He'll also be given information on how to contact you. You're gonna have a seat in that chair on the corner and go to the window when your name is called. All right, here you go.
Trina just called about Jenna Aldridge. She said that she's gonna appear in Zoom because she can't get her.
Okay. Yes.
This is Travis, I was in the
Okay, hold on a minute. Would you come on up? Mr. Prosecutor? Okay, this is clause number 327-344. Case is style of State of Texas versus Travis Ray Ozan. Mr. Ozan, how you doing?
All right.
That's good, Ms. Ozan. You're represented here by your attorney, Attorney Tom Burbank. Attorney Burbank, how you doing?
I'm fine, Judge.
And the state is represented by Attorney Lamar Johnson. Attorney Johnson, how you doing?
I'm doing well, y'all.
And Mr. Burbank, you have an announcement?
We do, Judge. Mr. Ozan would like to address the court, and just for a little background, Judge, because we're trying to get this settled. He is charged with an enhanced DWI with an alcohol content of 0.16.
Okay, let me do this
Well,
here.
here's,
You said he wants to address the court.
yeah, he
I mean, let me actually see, do y'all have a plea bargain agreement?
trying to, Judge, but.
I mean, I can't get involved with any negotiations between you and the state.
No, he wanted to talk to the court because he said, I'm not doing my job. So
Well,
I just
well-
wanted to,
I mean, if there's ways to deal with that, I can't.
well, how would you like to deal with it, Judge?
Well, I mean, you can deal with, but I can't tell you what to do in the case. I
Oh,
mean,
no, I
this is
want
not
you-
your first time having a client that may have been upset. I mean, that happens from time to time with all lawyers. But the court is not going to get involved in that aspect of your client, your attorney-client relationship.
No, he wanted to address the court, Judge.
Well, the court is not gonna, if it's that, the court is not gonna address that issue. Okay, there are ways to approach the court in terms of appropriate motions that needs to be filed. So at this time, the court is not going to get into no, yeah. Yeah, okay, so
Would
Mr.
you like to
Ozan, the
take
court,
the offer, or would you want to reject it?
No, I don't feel you.
Okay.
I don't feel you either. You working for my bad.
okay, well, Mr. Ozan, there are ways to, you can remedy that. I can't tell you what to do. I can't give you no legal advice. So, I mean, at this time, right now, he's still your lawyer. Okay. And so you can, they made it offer, you can accept it or reject it. And whichever decision you make, then we'll go from there. Okay?
Sure.
Okay, so, I could give you some time to, you want to sit down and think about it for a minute? Okay, we'll call you back up later. All right,
Thank you.
okay, you're welcome. Who do we have? Okay. Samantha Jones? Okay, this is cause number 326-354, case is styled the state of Texas versus Samantha Nicole Jones. Ms. Jones, is that your full name?
Yes.
Ms. Jones, would you please raise your right hand? Ms. Jones, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Ms. Jones, you may put your hand down. How are you doing, Ms. Jones? You okay? That's good. Now, Ms. Jones, I have before me a couple of documents. The first document I have is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant? And are these your initials on the line stating you want to apply for a court-appointed attorney? And Ms. Jones, I also have a document here that's titled Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, Ms. Jones, there is a signature above the line that is titled Defendant Signature. Is this your signature? Now, Ms. Jones, before you signed and initialed these documents, did you read the documents? And did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay. Ms. Jones? I've read your answers in both of these documents. Based on your answers, you meet the eligibility requirement for the appointment of a court-appointed attorney. And the attorney that will be appointed to represent you in this case is Attorney Ryan Matuska. Our court coordinator is going to give you information on how to contact Mr. Matuska. Mr. Matuska will also be given information on how to contact you. Once you get that information from our court coordinator, you'll be free to go and you have a blessed day. Please stand on the 4X in front of the court coordinator.
We have an announcement, Judge, about this.
Okay. Mr. Ozine, would you please come forward? This is cause number 327-344.
Has he gotten the pretrial conditions for bonding?
Yeah, but we don't, normally, he doesn't have a, look and see, well, yeah, they didn't have nothing from the jail. Yeah, we don't have none on this type case. Okay, now, Mr. Ozine, you're here, represented by your attorney, Terrence Burbank. And Attorney Burbank, you have an announcement you'd like to make?
Yes, Your Honor. At this time, he'd like to reject the offer. He's going to seek other counsel, retained counsel.
Okay, so what we'll do, we'll reset this on an announcement docket.
Sure.
Give us, how much time do you need to get an attorney?
Well, at least a month.
Okay, we're gonna give you 60 days. Okay, that's 2 months. All right. Mr. Burbank, you gonna sign for the reset?
I would have him sign it, Judge, just in case he doesn't. I'll sign it also,
Well, okay,
but he needs to sign it too, so he has a notice of it.
okay. So once you get your reset, you'll be free to go. You have a blessed day. You have a blessed day as
May I
well.
be excused, Judge?
Yes,
Thank
y'all may be excused.
Thank
Y'all know. Next case is cause number 331920. Case is style of State of Texas versus Jeremy Arsenault. Mr. Arsenault, would you please come forward? The full name is Jeremy Arsenault.
Yes.
Mr. Arsenault, would you please raise your right hand? Mr. Arsenault, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? Okay, Mr. Arsenault, you may put your hand down. How you doing, Mr. Arsenault? You doing all right? Mr. Arsenault, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document? And is this your signature on the line that's titled Defendant?
Yes.
Are these your initials on the line stating that you want to apply for court-appointed attorney?
Yes.
Also, Mr. Arsenault, I have before me a document that is titled Affidavit of Indigence. Do you recognize this document?
Yes.
And on page 2 of the same document, there's a signature above the line that's titled Defender Signature. Is this your signature?
Yes.
Now, Mr. Arsenault, before you signed and initialed all of these documents that I've just mentioned to you, did you read these documents?
Yes.
Did you understand what you read?
Yes.
And is everything in these documents true and correct to the best of your knowledge?
Yes.
Okay. Now, Mr. Arsenault, I've read your answers in these documents, and based on the answers, you don't meet the eligibility. I don't think you meet the eligibility requirements for the appointment of a court-appointed attorney. So and I'm just looking at the information that you provided here. It seems to me that you may have some extra cash left over, I guess at the end of the month after, paying for your expenses. So at this time, the court is not going to,
Give me some time to get in time.
yeah, we can give you a chance to, opportunity to get an attorney. Okay, I think it's 6 a week. That's actually a little bit more than that. Yeah, so what we'll do, we'll give you some time to get one, and then we can, things change, we'll revisit it. Okay, so we're gonna reset it 60 days.
Could you give me something to write you out? So,
The court coordinator, you can ask the court coordinator, and they'll be able to get that information. You need something for your work?
yes.
Yeah, she'll be able to do that. Okay? All right, here you go. Okay, now the next case that we have is cause number 332830. Case is styled the State of Texas versus Gina Catherine Aldrich. Ms. Aldrich is appearing via Zoom. Ms. Aldrich, your case was set today for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your rights are, and what your options are concerning your case. Now, your case actually is classified as a Class A misdemeanor. And first of all, the court needs to inform you that as a defendant in a criminal case, you have rights. One of the rights that you have is a right to have an attorney. Now, with regards to your rights to have an attorney, you have 3 options. Number 1, you may hire an attorney. Do you understand that option? Okay. And number 2, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Do you understand that option? And number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. Now, that financial questionnaire, you have to be here in person to do that. Now, you may not speak to the prosecutor. The prosecutor is the assistant district attorney that is handling the case. You may not speak to him or her if there's a female prosecutor who's on the case when you come, unless you sign a written waiver of your right to be appointed to your right to be represented by an attorney. Now, a waiver that means you'll be waiving your right to have an attorney. You'll be giving up your right to have an attorney, and you will be representing yourself. So until you sign that written waiver, you will not be allowed to talk to the prosecutor if you're desiring to represent yourself. Now, be aware that there are dangers of self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you decide to waive your right to an attorney and to represent yourself, you may change your mind at any time and you may request counsel from the court. Now, there will be a document once you come to court that you will have to sign stating that either you want your case reset to hire an attorney, or if you've already hired an attorney, you'll sign the name of the attorney or place the name of the attorney on the document and you'll initial where it says that you have hired an attorney. And if you want to apply for a court-appointed attorney, there'll be an appropriate place for you to place your initial stating that you want to apply for a court-appointed attorney. Now, if you've already been appointed a court-appointed attorney, there's another appropriate place where you will sign the name of the court-appointed attorney and you'll place your initials on the line next to the attorney's name. And then if you want to waive your right to an attorney or give up your right to an attorney and represent yourself, then there'll be an appropriate place on that document that you will also be required to sign. Now, as a defendant in a criminal case, you not only have a right to have a trial, not only have a right to have an attorney, but you also have a right to have a trial by jury. And what a jury trial is, it will be 6 individuals that will be selected to sit on your case. They will decide, after listening to all the evidence, whether or not you're innocent, that means not guilty, or whether or not you're guilty of the charges. Now, you can waive your right to have a trial by jury, which means you can give up your right to have a trial by jury. And by doing so, your case will come before the judge in one of 3 ways. It will come before the judge by way of a trial by judge only. We call that a bench trial. Now, you also have a right to waive or give up your right to have a bench trial. Now, if you do that, the other way that your case will come before the judge is by way of an agreed plea bargain. A plea bargain is an agreement to settle your case that you've worked out with the state or with the district attorney. Now, if y'all have an agreement, then it will come before the judge, and the judge will decide whether or not the judge will follow or not follow the plea bargain agreement that you've worked out with the state. If the judge follows the plea bargain agreement, and if you decide within 30 days after entering your plea that you would like to appeal your case because you think that you've been wrongfully convicted or the court has committed an error by convicting you, then you would have to get permission from the judge to appeal your case. The other way that your case can come before the court is by way of an unagreed plea bargain. That is, you and the state has been unable to reach an agreement to settle your case, and so you want the judge to decide what the punishment will be in your case. If that's the case, we call that an unagreed plea bargain agreement. Now, you also have a right to have witnesses to come to court. And what witnesses do, they can testify either for you or against you. If you're representing yourself, you can ask them questions, or if you're represented by an attorney, your attorney can ask them questions. We call that either direct examination or cross-examination. Now, you can waive your right to have witnesses. That means you can give up your right to have witnesses, and by doing so, you will not be calling any witnesses in your case. However, the state will be calling witnesses in your case. Now, you also have a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. In essence, you have a right to see the documents, written statements, videos, pictures, photos. You have a right to see, have access to the objects or anything that they have that they consider as evidence. If you're represented by your attorney will have access to it. If you're representing yourself, you will have access to it. Now, you also have a right to give up, to waive your right to discovery. That means you have a right to give up your right to have discovery of the evidence in your case. Now, you're currently out of jail on bond. That means you was arrested and then you bonded out. Any day, any time that you spent in jail, it can be used as credit towards your punishment. For example, if you and the state has worked out a plea bargaining agreement for 5 days in jail, you have already served 5 days in jail. That means you won't have to serve any more time in jail. Why? Because you will be given credit for time that you have already served. Now, if the state is offering 7 days in jail and if you serve 5 days in jail, that means you have to serve 2 more days in jail. Now, any time that you spent in jail will also go as $100 credit per day toward your fine and court costs. So for example, if you have spent 5 days in jail, that means you have $500 credit that can go toward your fine and court costs. If the state is offering you fine and court costs of $500, that simply means that you will not have to pay the $500 because the 5 days that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired. Now, if the state is offering $700 fine and court costs and you serve 5 days in jail, that means you would have to serve, you would have to pay $200. Now, if you can't pay the $200 on the day of your plea, then the court can put you on a payment plan to give you time to pay it off. Now, if you're unable to pay it off because of lack of income, then the court can convert your fine and court costs to community service, and you will be given $12.50 for every hour of community service that you do, and that will go toward your fine and court costs. So for example, if you do 8 hours of community service in one day, that is equivalent to $100 that will go toward your fine and your court costs. Now, Jefferson County has a program that is called pretrial diversion. And what pretrial diversion is for first-time offenders. If you've never been in trouble before, Jefferson County has a program whereby if you get into the program, they will dismiss your case. And if your case is dismissed, then you complete the program, they can expunge it from your record, which means they can wipe it off or delete it from your record. Now, the other thing is if you are a veteran of any one of the branches of the United States military, then there's something that's called Veterans Court. And with Veterans Court, it's for veterans only, and it works the same way as pretrial diversion, which means they can give you, put you in the program. If the program is completed, the case will be dismissed and you can get it expunged from your record. Now, this court has a program that is called pretrial, that is called the Community Safety Initiative. And with the Community Safety Initiative, it's a program that we have with partners in the community. We have a partnership with Spindletop, which is our local mental health center. And Spindletop will be, they have people that can come in, they can do a private interview, they can do an assessment, they can develop a treatment plan to address any mental health needs that you may have. If you have any issues with drugs and alcohol, they also have a program that is called ATAR, which stands for Addiction Treatment and Recovery. and our local Alcohol and Drug Abuse Council has a program that is called OZAR. And both ATAR and OZAR can do a private interview, which is a screening. They can do an assessment, and they can do a treatment plan, either outpatient or inpatient as well. Now, also, if you are unemployed and looking for a job, we have a partnership with the Golden Triangle Empowerment Center. With them, you could be trained in the hotel industry, the shipping industry, or the chemical industry. And if you're trained in any one of those three areas, they will assist you at getting a job. If you have not graduated from high school and you would like to get your GED, they also have a program that can assist you at getting your GED, okay, which is your graduate equivalency diploma. Now, all of those programs that I just mentioned to you, they are free. It does not cost you anything. Only thing you have to do is have a desire to be in that program. And again, I told you that program was a program that that I started in the first 100 days of taking office in March of 2017. And all of those programs are free. I tell people this all the time: when you come to County Court at Law Number 2, we do not have court as usual. We have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before the court, and we're trying to make a difference in our community, because we're trying to produce productive people, and we believe that if we produce productive people will not commit crimes because they have too much to lose. We do not just give our time, we take our time, and we believe that it's better to address the problem, not just to arrest the problem. So, Ms. Aldrich, this will conclude your arraignment. We're going to reset your case for a date for you to come in to sign the necessary paperwork. Could you give us a reset date? Just hold on a minute. Okay, your case is going to be reset for arraignment on October 11th of 2022 at 9 a.m. Okay, and Ms. Aldrich, thanks for your time and attention. This will conclude your arraignment. You're free to go, and you have a blessed day. Okay, you're welcome. Jefferson County Court at Law number 2 is back in session with the arraignment docket, which was scheduled at 9 a.m. on today's date of September 13th of 2022. First case we're calling is Travis Santal Jones, cause number 286550. Travis Jones was scheduled to be in court this morning for our arraignment docket at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Travis Jones, and at the courthouse door, Travis Jones did not answer. Travis Jones has not appeared in court since the court has been in session. The time now is 11:25 a.m. on today's date. Mr. Bailiff, would you please call the name of Travis Jones at the courthouse door?
Travis Jones. Travis Jones.
Travis Jones' name is just called again at the courthouse door. Travis Jones did not answer. A reasonable time has passed to give Mr. Jones an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, state move the bond forfeiture.
That motion will be granted. Travis Jones' bond will be forfeited and warrant shall be issued for his arrest in cause number 286550. Next case is cause number 332560. Case is style of state of Texas versus Cedric Dwayne Adams. Cedric Adams was scheduled to be in court this morning at 9 a.m. for the court's arraignment docket. At or about 9 a.m., the court's bailiff called the name of Cedric Adams at the courthouse door. Cedric Adams did not answer. Cedric Adams has not appeared in court since the court has been in session. This time now is 11:27 a.m. on today's date. Mr. Bailiff, would you please call the name of Cedric Adams at the courthouse door?
Cedric Adams. Cedric Adams.
Cedric Adams' name was called again at the courthouse door. Cedric Adams did not answer. Cedric Adams has not appeared in court since the court has been in session. A reasonable time has passed to give Mr. Adams an opportunity to appear in court. He has not appeared in court. State, do you have a motion?
Yes, Your Honor, state moves the bond forfeiture.
That motion will be granted. Cedric Adams' bond will be forfeited and a warrant shall be issued for his arrest in cause number 332560. Next case is cause number 332832. The case is styled the state of Texas versus Courtney Marie Chapman. Courtney Chapman was scheduled to be in court this morning at 9 a.m. At or about 9 a.m., the court's bailiff called the name of Courtney Chapman at the courthouse door. Courtney Chapman did not answer. A reasonable time has passed to give Ms. Chapman an opportunity to appear in court. She has not appeared in court. The time now is 11:28 a.m. on today's date. Mr. Bailiff, would you please call the name of Courtney Chapman?
Courtney Chapman. Courtney Chapman. No response.
Courtney Chapman's name was just called again at the courthouse door by the court's bailiff. Courtney Chapman did not answer. A reasonable time has passed to give Ms. Chapman an opportunity to appear in court. She has not appeared in court. State, do you have a motion?
Yes, Your Honor, state moves the bond forfeiture.
That motion will be granted. Courtney Chapman's bond will be forfeited and a warrant shall be issued for her arrest in cause number 332832. And this will conclude the calling of the court's arraignment docket, which was scheduled at 9 a.m. on today's date, September 13th of 2022 in County Court at Law number 2. Judge Terrence Holmes presiding. Everyone, please have a blessed day. The court will be in recess until 1:30 for